Whether through natural birth, a surrogate birth mother, or adoption, you're now a parent, and that means you have certain rights and responsibilities. Parents are legally responsible for raising their children. This means you are to provide food, clothing, shelter, and medical care. You need to make sure they attend school, provide them with needed supervision, and manage their money for their benefit. To fulfill these duties, parents have the right to direct the upbringing of their children and to punish them, as long as clearly excessive force isn't used. They may control the social lives of their children. A child's rights to birth control and abortion are exceptions to the general rule.
Many people don't realize that parents only act as trustees of money their children earn or inherit. They don't have the right to use that money except for the benefit of the child who owns it. This rarely becomes an issue because the child is seldom aware of any misuse, and courts are reluctant to get involved. Parents aren't usually responsible for debts incurred by their children.
My 7-year-old accidentally broke a lamp in a department store. Do I have to pay for my youngster's accident?
Probably not, since the lamp was broken accidentally. However, if the store owner could prove that you knew that your child frequently had these types of accidents and you did nothing to prevent them, then you might possibly be responsible for the damage.
Danny's the local bully, and he broke my son's nose. Will Danny's parents have to pay for the medical bills?
In most cases, you won't be able to have Danny's parents pay for the damages to your son. But the law does vary from state to state. Almost half the states have enacted parental responsibility laws that make parents liable for the payment of damages resulting from the intentional acts committed by their children. The dollar amount can vary from $250 up to $15,000. Overall, parents aren't responsible for the conduct of their children. If a child accidentally causes damages or injures someone, the parent may not be responsible at all, or may be liable for property damage only, or may be responsible only up to some low amount, or may be fully liable. As I said before, parents are more likely to be held liable if the child acted maliciously, if the parent knew of similar conduct in the past, or if the parent himself was negligent in supervising the child. In California and some other states, parents are not liable for the negligence of minor children. They are, however, liable for the willful misconduct of that minor child. Parents are seldom held responsible for a child's crimes. The minor is usually tried in a special juvenile court system that operates on the assumption that the child can be rehabilitated. The juvenile court only has jurisdiction until the child reaches the age of majority.
Judge Wapner, my 15-year-old son, JP, was playing catch with a baseball and he accidentally broke the windshield on a Mercedes. Do I have to pay for this?
Probably not. The only times you as a parent would be responsible for JP's actions are 1, if you contributed to the damage by giving JP something obviously dangerous, and 2, if you knew JP was doing something wrong and didn't try to prevent it, or 3, if JP was acting on your behalf. The owner of the Mercedes can probably get reimbursed from his car insurance company.
Our 22-year-old daughter has moved out of our home and has a job and an apartment in a nearby city. She owes $2,000 to a hospital in her area. Since she can't pay the bill, the hospital's going after us. Are we still responsible for her debts?
No, you've been emancipated. A parent's responsibility continues until the child reaches the age of majority, which is 18 in most states, marries, or leaves home to become self-supporting. Your responsibility may continue past 18 in some states if the child is disabled.
One of the responsibilities of parents is to protect their children from abuse. Child abuse has received an enormous amount of attention in recent years, and states have been changing their laws to encourage people to report suspected cases of child abuse. Most states require teachers, doctors, and social workers to report suspected abuse.
This is why child care professionals are granted immunity from libel and slander suits for speaking out when they see a possible case of abuse. Special statutes define the level of physical or emotional punishment that constitutes abuse. They cover sexual molestation and other harmful conduct as well. The state may remove a child from the custody of its parents if a court decides that the child's being abused or if the parent is neglecting the child. By neglecting, the court means failing to meet the child's basic needs. Courts are reluctant to do this. They almost always remove a child from the home on a temporary basis and are seldom reluctant to return the child to the home if there's a change of circumstances for the better. In some highly publicized cases, children who've been returned to abusive parents have been tortured and killed. But the courts and social service agencies have a tough time balancing the rights of parents and the needs of children when the facts aren't clear, or when poverty is widespread and foster parents are in short supply.
I'm almost positive that my neighbor is abusing her child. Is there anything I should do?
As a responsible citizen, you should report your suspicions to the Child and Family Service Agency that handles child abuse. The agency will look into the allegations and take appropriate actions if needed. Rest assured, your name will be kept confidential.
When most people hear the term family law, they think of divorce and child custody. Up until now, we've spent quite a bit of time covering other aspects of the law as it affects spouses and children. Now, we'll turn to the subject that causes so much bitterness and heartache for so many, the breakup of a marriage.
I need to warn you first that the laws on this subject vary from state to state in important ways. So do the terms used to define relationships. You may be able to do your own divorce, but you need advice from a lawyer about your rights and options before you initiate anything. Try not to let emotions cloud your judgment.
The first step in many divorces is a separation. A separation is basically a mutual agreement by a husband and wife to alter their marital relationship. This may include a decision to live apart, to stop having sexual relations, and or to redefine their rights and responsibilities with respect to property and children. A person who's separated remains married and so may not remarry. In some states, a wife would still inherit from her spouse if he died, even though they were separated.
There are several different ways for a husband and wife to separate. A truly unfortunate way is when one of the two simply leaves with or without notice. This is known as desertion and may afford separate grounds for divorce. Courts often look unfavorably on desertion in deciding which spouse will retain custody of the children or in deciding which spouse will retain ownership of the house and other property. Sometimes a couple simply agrees to live apart and end sexual relations. This is called separation by mutual consent. If a husband and wife choose to separate in this way, I would advise that they draft a written agreement with the help of separate lawyers. The agreement should contain provisions dealing with the division of their property, financial support, custody of their children, visitation rights, financial support for their children, and any other matters of concern. Such an agreement is a binding contract that either party can sue to enforce. If a husband and wife can't agree on their own to a separation, one or both of them may have to go to court to obtain one. This second alternative is called a judicial separation, legal separation, or limited divorce. A judicial separation often involves a court order stating the terms under which a husband and wife will live apart. These terms are often the same as if the parties were divorcing. In some states, a judicial separation becomes a divorce after a certain period of time, unless one party objects.
An annulment is a civil or religious court ruling which ends a marriage between a husband and wife. An annulment is often thought of in the same terms as a divorce, even though legally the two are different.
Before I discuss divorce, I'd like to mention briefly annulments. An annulment is a ruling that a marriage wasn't valid from the beginning because of a problem that existed when the marriage took place. An annulment might be granted if one party was already married, or underage, or if the union between a husband and wife involved some sort of fraud or duress. The sorts of fraud that might entitle a person to an annulment would be concealing an inability to have children or sexual relations, falsely claiming pregnancy, or concealing a divorce, serious criminal record, or drug addiction. Annulments can be granted by both a civil court and by a religious authority. To be legally binding, however, you must get an annulment granted by a court.
Judge Wapner, could you explain the difference between an annulment and a divorce?
In theory, an annulment is a recognition that a marriage never existed. In practice, an annulment isn't that different from a divorce. The law considers children born of parents who either divorced or whose marriage was annulled as legitimate. The law also allows people who end their marriage in either of these two ways to remarry. Many courts will also distribute property and order support payments after an annulment. The results of a marriage that ends in divorce or an annulment are quite similar.
Now that you understand separation and annulment, let's define the final step in the breakup of a marriage. A divorce is a court declaration that ends a marriage. A no-fault divorce is called a dissolution in some states. After a divorce, the parties are free to remarry and have only the obligations to each other that are contained in the court order ending the marriage. This may include provisions regarding child custody and visitation, support payments for spouse or child, and a division of marital property.
I've been married for 22 years, and I want a divorce. What steps should I take?
There are 5 key steps that I would recommend.
First, make an appointment with an attorney.
The earlier you do this, the better. You will want to have a different attorney than your spouse, and you'll want to have an attorney with whom you're very comfortable and in whom you have complete faith. If you cannot afford to hire a lawyer, you should ask your local legal aid society for help. Legal aid societies are designed to provide legal assistance to those who cannot afford it. They will decide to accept or reject your case on the basis of your financial need. If they turn you down, ask to be referred to a lawyer who might handle your case for a minimal fee. Work out an easy payment schedule, or be willing to accept as payment any fees the court might obtain from your husband.
Step 2, write down a list of all the major family assets.
This list should include, but not be limited to, cars, homes, televisions, stocks, bonds, and bank accounts. This list will be important in determining a fair settlement.
Step 3, make sure you know the contents and location of all important documents, including deeds and insurance policies. Step 4, if you've been financially dependent on your husband, draw up a budget estimating all of your monthly living expenses.
This will be necessary when you determine the amount of support you'll need from your husband after the divorce.
And step 5, try to set aside some money to cover your expenses while the divorce is pending.
The divorce process isn't always a quick one, and this nest egg will give you an added sense of security during this emotionally draining time. If it is legal in your state, you may want to consider a no-fault divorce. The majority of all divorces in America today are no-fault divorces. Many states have even abolished their traditional fault grounds for divorce. What makes no-fault divorce different is that the party suing to end the marriage doesn't have to show that the other spouse did something wrong that destroyed the marriage. The typical wrongs cited in a fault divorce are adultery, desertion, and physical cruelty. In a no-fault divorce, the filing party only needs to allege that the marriage has suffered an irretrievable breakdown, that the parties have irreconcilable differences, that the partners have become incompatible, or whatever the code words are in the state's no-fault law. The other spouse can do little to contest the divorce. What this means is that almost all of divorces today are uncontested in the sense that the responding spouse doesn't challenge the other's right to a divorce. The term uncontested, however, is misleading, and it's best avoided altogether. Virtually every divorce arises because of disagreements between the partners, and it's a rare case where the parties don't contest some aspects of the divorce. Many divorce lawyers are fond of pointing out that they've never really ever seen a truly uncontested divorce.
My wife and I have agreed on a divorce. We now reside in different states, neither of which is the state in which we originally got married. Who should initiate the divorce?
Either one of you may initiate it. Any state has jurisdiction to grant a divorce if either spouse is a resident. Most states require that a person be a resident for 6 months or a year before filing for a divorce in that state. A divorce in one state that was properly obtained under the rules of that state is valid in every other state. But let me warn you, United States citizens who get quickie divorces from Mexico, the Dominican Republic, or other countries on the basis of a short trip will find that the divorces will seldom withstand a challenge. I strongly suggest that you consult an experienced family lawyer before trying to obtain a foreign divorce of this sort.
What are the procedures I can expect to go through during the course of my divorce?
State procedures and terms vary considerably, but the basic idea is the same for all states. One spouse petitions the court for a divorce and notifies the other spouse of the petition. The second spouse has a period in which to respond. If the second spouse doesn't answer the petition or doesn't object to the petition, the divorce proceeds uncontested and is resolved rather quickly. A judge will then hold a hearing and in most cases approve of the divorce and any arrangements the spouses worked out regarding support, child custody, and the division of property. If the second spouse contests the petition, however, then the husband and wife must generally work out their differences with the assistance of lawyers or ultimately at trial. At this point, one or both spouses usually petitions the court for interim orders. Interim orders are temporary decrees that set forth each spouse's rights and responsibilities during the time before the divorce is final. In many instances, the spouses will continue to negotiate and ultimately settle their differences before trial. If not, a judge will hear the case without a jury and decide on the issues involved. It's the judge who will make final decisions that affect the division of property, child custody, spousal support, visitation rights, and other issues of dispute.
I just filed for divorce and I plan to get married again as soon as it's final. How long does a no-fault settlement usually take?
There's usually a waiting period between filing for divorce and getting a final decree. This can be as little as several weeks or as long as 3 years. For this reason, the state in which you file for divorce can be an important factor. The long waiting periods are in states that only allow no-fault divorce after a couple has lived separately for a set period of time so that there's ample opportunity for reconciliation if possible.
My husband and I are ending a 2-year marriage without children. Do we need a lawyer or can we save the money?
In some states, most notably California and Arizona, a majority of all divorces are obtained without a lawyer. Here are the guidelines under which it may be advisable to handle it yourself.
Both you and your spouse feel you know what you're doing.
The split is reasonably amicable.
There aren't any children involved.
The amount of property you own jointly is modest.
The ownership status of the property is not in dispute.
In any case, both you and your spouse should at least consult a lawyer about your respective rights and options. You may decide that you can do the paperwork yourself or do it with just a little guidance. But please don't decide to do so without talking to an attorney first. Both of you must feel comfortable doing it yourselves. Otherwise, the uncomfortable or less knowledgeable person may successfully seek to modify your agreement later.
When my wife and I started our divorce, our attorney suggested mediation. What is it?
Mediation is becoming increasingly popular as a way to reach divorce settlements. In mediation, the parties negotiate with the help of a trained mediator. Supporters of mediation say it promotes agreement because the mediator works for and tries to find middle ground for both parties, whereas lawyers have a duty to get as favorable a deal as possible for their clients. The parties may also be more apt to carry out an agreement if it's one they've reached themselves, as opposed to one fashioned by a judge or through their lawyers' negotiations. Mediation works best when the parties' positions are fairly equal and both are willing to talk and compromise. Where spouse abuse has occurred, or one party has dominated the relationship, mediation probably won't work. Courts in many places are experimenting with court-supervised mandatory mediation. Lawyers, by the way, can, and often do, serve as mediators, though the skills of a good lawyer are in some cases different from those of a mediator.
What should have been a very simple divorce became complicated when my husband and I tried to divide the property we had acquired during 10 years of marriage. Do you have any suggestions for making it easier?
Dividing marital property is sometimes the most difficult part of a divorce. Few divisions are actually done by a judge, but what a judge would be likely to do will shape the couple's negotiations. State standards vary about property settlements, but the general goal is fairness. Many states allow the court to divide separate as well as marital property. The longer the marriage, the more likely that property will be split pretty equally. Most community property states presume an equal split. Virtually every factor you might think relevant will be considered by most courts. These include the needs of each spouse, their abilities to earn income, the needs of any children, any lost opportunities to earn money or enter a career, tax effects, and numerous other issues. One common but difficult situation is where there are minor children and the couple's home is its major asset. The home can't be given to either spouse because there just isn't enough other property to compensate the one who gives it up. If the parent who has custody of the children wishes to remain in the home and raise the children, the house won't be sold until the children are grown or the custodial parent moves voluntarily. Any profit is then split between the former partners. Various arrangements can be made to assure that mortgage payments are met, the property maintained, and liens avoided.
My son was just divorced and has to pay spousal support. I never heard of that.
You've probably heard it called by another name. What used to be called alimony is now called spousal support or maintenance in most states, and the terminology change reflects changes in theory and practice. Support is awarded on the basis of need and is often temporary. The assumption is that both former spouses will work outside the home after the divorce if they're of working age and not incapacitated. A spouse who hasn't worked outside the home may get temporary support while she undergoes training for a career. This is often called rehabilitative support. Permanent support will be granted to a spouse who can't work or to one whose earning ability is low because she hasn't worked outside the home for many years. Ability to pay and the couple's former standard of living are factors in setting the level of support. Today, support isn't used to punish a spouse. Furthermore, no longer is a non-working spouse who's able to work entitled to continue her former standard of living without getting a job. Courts recognize that both parties to a divorce usually suffer financially from breaking up.
I worked to put my husband through medical school. Now that he's a doctor and beginning to earn a good living, we're getting a divorce. It doesn't seem fair that I won't get any return on all the tuition I paid.
The laws are changing, and you may be pleasantly surprised. One recent development concerns a situation in which one spouse has helped finance the education of another spouse during their marriage. If the couple has few assets, the court may award the first spouse part of the expected earnings of the other spouse with a higher education. The reasoning is that both spouses actually contributed their efforts to obtain the education, and so both should share in the earnings.
Child custody after a divorce is the right and duty to care for a child on a day-to-day basis and to make major decisions about the child. A long time ago, fathers usually had the right to custody of their children. Only beginning in the mid-19th century did mothers begin to be favored for the custody of younger children. Today, joint custody is popular in many states, but the welfare of the child is always paramount. The court's duty, if the parents can't agree, is to decide what's best for the child.
Consider for a moment the plight of the family court judge who must decide what arrangement is in the best interests of the children he doesn't even know. The decision will inevitably disappoint at least one parent, and it can create deep psychic scars and lifelong resentments. And in many cases, no thoughtful judge can be completely confident that his decision is the best one. That is why courts encourage parents to work out their own arrangements. Most judges will ratify any custody arrangement that both parents agree on. In an increasing number of states, including California, mediation is mandatory when the parents can't agree. Contrary to what many people believe, few lawyers relish bitter custody disputes. Family law attorneys almost always encourage negotiated agreements and can be invaluable in reaching them. They know where other people's arrangements have broken down. They're familiar with complex aspects such as taxes and out-of-state travel, and they'll assure that nothing essential is overlooked.
If you're facing separation or divorce and have minor children, working out a satisfactory custody arrangement is probably your top concern. Here's some basic information that can help. Number one, seek counseling first.
Some people are too proud or too timid to seek professional help when they should. Churches, social service agencies, and friends are excellent sources of referrals as well as help. Courts will have lists of family counselors specializing in family problems. Get your spouse to participate if possible, or go alone if you must.
Number two, don't move out of the house, initiate a divorce action, or reach a custody or property agreement without discussing your situation with a lawyer.
If you're considering divorce, it means that your interests are different enough from your spouse's for you to need expert advice about your rights and obligations. Your lawyer won't obstruct an amicable settlement. It sometimes seems that way, but that's because lawyers must raise issues that need to be addressed, issues that you might overlook. Think of your lawyer as an information source. You need to know what the law is and what a judge is likely to do, so that you can arrive at a fair agreement yourself.
Number three, the standard for deciding custody is always the best interests of the child. Traditionally, custody by the mother with visitation and financial support from the father have been the rule. Today, joint custody is preferred in many states and commonly ordered in the others. Joint custody appeals to judges because it's usually a compromise that softens tough decisions. Child psychologists generally feel frequent contact with both parents is best, unless relations between them are so poisoned that the child feels to blame and is disturbed by the extra conflict involved in moving back and forth between parents. Number four, joint custody is flexible. Joint custody doesn't mean that a child must spend equal time with each parent. There is joint legal custody and joint physical custody, and you can have either or both.
Joint legal custody means sharing information and responsibility for important decisions about your child's health, education, and welfare. Joint physical custody means that the child spends time living with each parent on a regular basis. Common arrangements include weekdays with one, weekends with the other, or school year with one, summer with the other, and so forth. The exact arrangement is up to you and the other parent if you agree, or to the judge if you don't.
Number five, custody fights can be nasty and expensive. If you can't agree about custody, even after mediation and with a lawyer's help, things can get very unpleasant.
What will happen is both sides may try to enlist friends, neighbors, and relatives as witnesses. The opposing lawyer may depose you, asking questions that you must answer under oath and with a court reporter recording everything. You may even be ordered to undergo a psychiatric examination by the other side's chosen expert. You can do the same to your spouse. The emotional and financial cost can be very high.
Number six, custody arrangements are easy to change if you both agree. Changes need the judge's approval, but that will normally be routine unless there's a dispute.
Changes are very difficult to get if you don't agree. You can be jailed if you violate a custody order, and you may end up losing any custody rights that you had.
Number seven, custody and support are separate issues.
Don't prevent visits or violate a custody order just because your former spouse is behind on child support payments. See your lawyer instead. The same goes if your former spouse does not allow you to visit your children. Keep up the support payments and see a lawyer if you can't work it out.
A non-custodial parent, the parent who does not have primary custody of the child, is normally entitled to reasonable visitation, unless visits would not be in the child's best interest. This might be the case where alcohol or drug abuse occurred, or where child abuse was suspected.
There isn't much law to discuss about visitation, but it's certainly a common source of friction between former or separated spouses. It can be difficult to be objective about your child's best interests. It's hard not to compete with the other parent for your child's attention and affection. Visits force contact with your ex that may be painful. Just do the best you can and try to keep visitation from being a weapon to punish or threaten your spouse at the expense of your child. As with custody and support, judges would prefer that you make your own decisions, even though the court will referee if you insist.
My son is divorced, and his ex-wife, who has custody of the children, has remarried. I miss my grandchildren very much. Is there any way I can get visitation rights to see them?
Many states will grant visitation rights to a grandparent whose child doesn't have custody of the grandchildren. Obviously, the closer the relationship with the grandchildren before the split, the better the chances of getting visitation.
One of the most difficult aftermaths of some custody battles is the issue of child support. Judge Wapner has some important advice on this recurring problem.
In discussing the issue of child support, I'm going to spend only a minute on the standards for setting support, but then go into some detail about the new federal laws on collecting child support. I want to do this because collecting support is the real legal problem both the country and many custodial parents face, and the new law is potentially very helpful. Both parents have an equal duty to support their children. If one parent has custody, the other normally owes child support. If they share custody equally, the parent with more available income normally pays more child support. The idea is that the expense of raising the child should be split between the parents on a fair basis. All states have guidelines for setting support. These include
The financial needs and resources of each child,
The financial needs and resources of each parent,
educational and other needs of the child,
special emotional or physical needs or conditions,
the child's standard of living before the separation, and the standard the child would enjoy if the marriage hadn't ended.
and the value of services rendered by the custodial parent.
a parent who's liable for child support is required to include the children in any group health plan that parent is eligible for, unless the other parent already has better or cheaper coverage.
The percentage of American children who qualify as poor has risen sharply in the last 20 years. Children in this country are much more likely to be poor than older people, and children in single-parent households are especially likely to live in poverty. With government resources concentrated elsewhere, getting support money from absent parents has assumed increasing importance in the last decade.
Congress has acted to require states to improve their enforcement of child support orders, make the size of support payments more uniform, and cooperate more efficiently with sister states in collecting payments. Still, there's quite a bit of room for improvement. In 1987, the Census Bureau found that only half the parents who were owed child support actually received the full amount. 1/4 received nothing, and 1/4 received only a portion of the court-ordered payments. The average support payment in 1987 was 25% lower than a decade earlier, and that's after adjusting for inflation. One study showed that 58% of the nearly 9 million mothers who might be entitled to support didn't have a court order for it. They may not know who the father is, may wish to avoid all contact with him, may lack the money to go to court, or may know the father has no job or resources. To meet these problems, the Family Support Act of 1988 and its predecessor the Child Support Amendments of 1984 have the following provisions.
Mandatory payroll deduction of child support is required in most cases.
Attachment of property and interception of tax refunds have made it easier to collect overdue support.
The burden of enforcing support orders has been transferred from the custodial parent to the states.
The discretion of the judges in setting the amount of payments has been reduced.
Job training and placement must be offered to parents who owe support.
Financial incentives will be provided to states so they'll enforce support orders from other states.
Wage withholding should strengthen the position of custodial parents, but it can help non-custodial parents as well. By making payroll deduction the general rule, the stigma of having payments withheld is reduced. With enforcement in the hands of the state and not those of the parents, it will tend to be less a source of friction between the parents. Reduced friction can improve cooperation over visitation issues, not to mention the well-being of the child involved. With the size of payments less discretionary, there may be less fighting and resentment.
If you're involved in a child support situation, be sure to ask your lawyer whether new or proposed changes in the system in your state will affect you. Even if you've been paying or receiving support steadily, there may be things you need to know about your future rights. You could also contact the Child Support Enforcement Division of your state's Social Services Department. As always, remember that the general information provided in this talk isn't a substitute for legal advice from an attorney. For specific advice based on your own individual circumstances, see the lawyer of your choice. You may want to listen to Judge Wapner's cassette, You and Your Lawyer, for assistance in selecting and working with an attorney.